Hi, my name is Leon Versfeld. I'm a U.S. immigration attorney. And in this video, we're going to be dealing with some of the questions that you've left for me on Twitter, on LinkedIn, and on Facebook. One of the more common questions we get in the E-Treaty visa is how much money I should invest. Well, there is no minimum investment like with the EB-5 green card where you need to invest a minimum of $500,000. It all really depends on the model of your business. If you're coming to the United States to open up a business where you are going to be selling cars, one would expect that the minimum investment for the inventory that you are going to be buying and the area and the lot that you're going to need to store these cars on would be significantly more than a guy coming over to provide a service, IT service or consulting service. So these minimum investments really is determined on your business plan and how much it is that you are investing in order to make this company viable to a certain point where you are able to draw a minimum salary out of the company without needing to lean on the government for any help. I hope that this answer is sufficient, but each case is unique, and I encourage you to engage with me if you think that an e-visa is something that you qualify for and that we need to discuss further. Another common question that we get is, do I need to have a job before I come to the United States? Well, it boils down to the very essence of whether or not you have a U.S. company who's willing to sponsor you before you come to the United States. If you do, however, have a U.S. company who's willing to sponsor you and willing to provide you with a job, then that starts the inquiry with regards to what visa options there are available. I encourage you to engage with us and my team in coordinating a free telephone consultation so that we can explore those possibilities if you have a U.S. employer who's willing to sponsor you. A follow-up question is, what are the chances of me getting an H-1B visa if I do happen to find a U.S. employer who's willing to sponsor me? Well, that will really depend on what time of the year we are having this conversation, because H-1B season really starts in April 1 with a start date of October 1. So even if the H-1B may not be a viable option for you because of the fact that the H-1B visas may be used up, we may discuss some other options. The fact that you have an U.S. employer who's willing to sponsor you for an immigration benefit, I think puts you already a mile ahead above other folks who are looking to find an immigration way to come to the United States. Another question we oftentimes get is, if a U.S. company is willing to sponsor me, will the sponsorship entail a permanent visa or a temporary visa? Well, this really just depends on which avenue and which route we follow. It could be both. A temporary visa typically does not take as long as a permanent visa, which a permanent visa is typically referred to as a green card. We can get both processes going at the same time. Also, depending on what time of the year we're having a discussion with regards to a temporary visa, will determine on which visa classification we're going to pursue and when that visa would be available. As we have discussed in many of our other videos, one of the more popular visas, the H-1B, is very limited. And depending on what time of the year we are having the discussion, it will be viable for us to come up with a strategy that is viable for you and your employer to determine how soon we can get you over to the United States. A question we also oftentimes get from new and existing clients is, if a U.S. employer is willing to sponsor me, how long will the process take? Well, this really kind of depends again on what kind of visa classification we are pursuing, what time of the year we are pursuing that visa classification, and what the timing is of you needing to be in the United States. All of these factors are individually based, and because it's individually based, I encourage you to coordinate with my team for an individual discussion with you and your employer to discuss a strategy that's best for you. Oftentimes when a client approaches me with regards to requirements to come to the United States, I get questions like, do I need to have a degree to come to the United States? I'm 60 years old. Would that disqualify me from coming to the United States? Depending on which immigration classification we pursue, education may or may not play a role, but age would never play a role. Unlike Australia and some of our other popular immigration countries, age does not play a role with regards to your immigration benefit. For some of you who have considered the L intercompany transfer, where you utilize your current South African or your foreign company to springboard you to the United States in opening up a new company, I've oftentimes been faced with the question that, hey, my foreign company is still brand new or still relatively new. Will this be a hindering block for me to open up a company in the United States? Well, it is important to note that with the L intercompany transfer visa, you need to show a couple of things. Number one is that you have worked for the foreign company for at least 1 out of the last 2 years. So if your company is less than 1 year old, obviously it's not going to qualify. Secondly, you will also need to show that the South African or foreign company that you are currently working for is in financial good standing so as to allow the foreign company to be started up, because the foreign company would in of itself be the one giving that initial boost to the US company in its initial year. So the financial status of the South African or foreign company in this case is vitally important for purposes of the L1 process. One of the last questions that we will address on this video is a question we had from one of our South African clients who wants to start up a company in the United States that will ultimately be the company sponsoring him and his family to come over to the United States. How that then contrasts with those that are coming over, starting up a company from being a national from a treaty company. Well, the main difference between the e-treaty visa and my South African scenario is that the e-treaty visa is specifically designed for nationals from those treaty countries to come and start up a company and get an immigration benefit because of their entrepreneurial skills. Whereas my South African client would not get that immigration benefit, and it will be very difficult for that newly formed US company to sponsor my South African client. One of the more popular questions we get is, how will Trump affect the US immigration system? Well, this is a very important question because the US immigration is an administrative process dictated by policy. So even though there may not be a change in law, which we are all hoping for, a change in policy could dramatically change how immigration implements the laws that are currently on the books. Mr. Trump has given some directive to the Department of Homeland Security, and through his common thread and theme to make America great, to put the American worker first. We are already seeing some proposed changes in policy in the H-1B program, in the L visa program, in the seasonal worker program, where some of these policies are trickling down on how immigration is implementing the current immigration legislation. I hope that these questions and answers have been helpful to you. I encourage you to continue to engage with us on our social platforms on Facebook, LinkedIn, on Twitter, and subscribing to our YouTube channel to keep up to date with regards to how these potential changes that the Trump administration are making to the immigration process affect you or may potentially affect you.